Fantastic. Don't they say it all the time? Maui no ko'oi, all right? Absolutely. Well, I'm delighted to be with you today. I'm Keli Akina, president of the Grassroot Institute. I'm also a trustee at large in the Office of Hawaiian Affairs, but I'm here in my personal capacity. And today we're going to meet a gentleman who is the expert in his field, the study of land use policy here in the state of Hawaii. I'll introduce David Callies a little bit later. I'm looking forward to what he has to share, and you'll have an opportunity to hear from him and ask him some questions. But let me share with you a little bit about how we think at the Grassroot Institute. One of the things that's so important is to allow people to be free. For example, if you have 2 apples, but you don't want to eat apples today, and you meet somebody who has 2 peaches, and they don't want to eat peaches, but they want to eat apples, you can get together and give your 2 peaches to that person who will give you 2 apples. You both will enjoy the fruit and leave that transaction happy. Doesn't that sound like a happy world to live in? And that sounds fair, and that sounds right, and it works out very nicely in terms of pricing the economy for fruits. But what happens if the government observes you and says, now wait a minute, there are people who can't afford your apples, and so what we want to do is force you to pay, to sell to them at a lower price. And 1,000 different rules later, you're out of the apple and peach business altogether, and you're not exchanging. When there's a fair exchange between the supplier and the demander, we call that a free market interaction. The problem is that doesn't work in Hawaii anymore because the government is so involved. Now, don't get me wrong, I'm not against our government. If you decide to take a knife and thrust it into me, I'd like a policeman to come when I dial 911. I think that's a good thing. Or if you want to cheat me out of a contract deal that we have, I'm glad that we have courts that can uphold that. That's the good use of government. But there are things government does that don't actually work out right, particularly when government tries to interfere with the economy. Now, how many of you have been watching every single day the reports about the lava floods on the Big Island? And you also know, you've probably thought it through, that that is exacerbating the housing problem on the Big Island as well. And it's causing taxpayers to have to pay a lot more money for the emergency relief services, and it endangers the general public. But did you know that in addition to Madam Pele, there's another cause for the trouble we see? Grassroot Institute has done breakthrough research that we are now circulating to the media, and that's this story. People built homes in lava zones 1 and 2, which were known to be very dangerous, because they could get insurance. Now, the story goes back several years. There was a time when you couldn't get insurance because of the number of times the volcano erupted. And every single private insurance company said, we're not crazy, we're not going to sell people insurance because this is a losing deal, both for the buyer of the insurance and the insurance company. But guess what? Your state legislature decided to step in and say, that's not fair to people who can't get insurance. And so they required the insurance companies to set up a consortium and force them to pay and subsidize for insurance. And as a result, thousands of people bought insurance and started to build homes in zones 1 and 2, which are dangerous in terms of the lava flow. Well, the rest of the story is unfolding this week as we see dozens more homes lost and so forth. What went wrong here? Was it that they had insurance available? No. What went wrong is that the government forced people to do something and forced the rest of us to pay for it. Well, long story short, when you ask the question here on Maui, why is housing so expensive and why is it so unavailable for many people, part of the story, a big part of the story, has been tracked by David Callies, and that is the role government has played in trying to regulate the housing and land market here on Maui and in the state of Hawaii. He's an expert in his field. David Callies is a professor at the University of Hawaii Richardson School of Law, and from time to time I meet young attorneys who have graduated, who've learned under him. They just rave about his courses. I'd like to go back to school and take a course or 2 from you, but I have to settle at my late age in life for the book that he's written, which is the book It starts with the title, Regulating Paradise. Now, he'll tell you the whole title, but if there's one book you want to read to help explain the maze of zoning and land use laws in the state, it's Regulating Paradise. He's received national awards for his work. He's also an expert on how state and local governments work. David Callies continues to teach at the University of Hawaii. He's going to share with you for about 30 minutes, and then I want to welcome you to come up to this microphone at which I'm standing so that you can ask him any questions that you have. So jot your questions down, but remember, you'll have to come up to the microphone. But before I introduce him again, I want to say thank you so much for joining us at the Grassroot Institute today. And now, ladies and gentlemen, please welcome Professor David Callies. David? Thank you. Your microphone is right here.
Dr. Akina, thank you very much. It's a pleasure to be here. Just remember that the expert is the guy from out of town. I'm off island. And so I guess that makes me an expert because I don't live here. Although, of course, I've been in the Hawaiian community for about 40 years and first visited the islands in about 1970, which dates me. Please don't do the math. I'm sensitive. The burden, and again, I want to thank you for that warm reception and to thank the Grassroots Institute for providing this invitation and opportunity to speak to you. I'm going to deal with several issues that have to do with or are related to the cost of housing. None of the regulations that I'll briefly talk about are in themselves meant to be pernicious or driving up the cost of housing. There was no animus involved. All of them had good purposes and good reasons, but collectively, I guess I have two bottom lines. Collectively, the regulations, because there are so many of them, we being the most overplanned and overregulated state from a property standpoint in the country, has the effect of driving up the cost of housing because of the permitting process, which we euphemistically call entitlements, which has got it backwards. You know, folks have the right to use their land except when their land injures the health, safety, and welfare of the people. It's not the other way around. It's not a privilege to develop, it's a right. And that's the way the Constitution works, and that's the way the law is supposed to work. The other major issue sometimes falls into the area of regulations, but it's more like, although it is not, a tax, and that's a financial burden that's imposed on the development, especially of housing, by means of so-called exactions and impact fees that most, if not all developers, need to pay before they can get approval of their various plans for development. So these two together help drive up the cost of housing a lot. Indeed, there was a survey done a number of years ago by a national and local team that the exactions imposed on the Big Island drove up the cost of a single-family detached house by at least $28,000 per unit. That is probably doubled on most islands right now and probably tripled in some cases. So the rationale, as I hope to point out, and the reason for the regulations and the reason for these impact fees and exactions are all benign, but the result drives up the cost of housing for everybody, and that is what is not benign, and that is really the problem. And then I would like to end with a little bit of lawyer talk. How many in the audience are attorneys? So I'm going to try not to talk to you guys very much, okay? I'm going to try and make it a little bit more general than that. But the truth of the matter is, I will get to towards the end of my time with you today, is to summarize the situation in a case that's wending its way to the U.S. Supreme Court that will be argued in the fall. That will, for what it's worth, make it easier to bring regulatory taking challenges against government when government goes, as Justice Holmes said in his wise decision on takings a long time ago, when regulations go too far, they become a taking of property for which compensation should be paid. So I'm not going to talk about eminent domain unless I have a question on it. I'll be talking mostly about the regulatory regime. And then towards the end, I want to say just a couple of words about the opportunity to participate in a referendum that will decide whether or not we have a constitutional convention. I commenced teaching at the University of Hawaii in 1978, just in time for about 10% of my class to be absent because they were con delegates. And it was an interesting process, and we have not had a con since, and we're nigh on 40 years, and I think, you know, again, mainly my opinion, I think that there's a good rational basis for having a con, and particularly one particular thing that probably needs fixing, and I hope to go into that a little bit first. So now, basically, to start out with the regulatory aspect, we are, again, the most regulated state and arguably overplanned state in the Union. Back when I began teaching, we had the advantage at the University of Hawaii to have Sir Desmond Heap come out as a visiting teacher. And Desmond Heap was the counsel for the City of London. And his claim to fame that everybody knew about, and I think some people who will remember, you know, most folks around my age will remember for sure, there was a developer in Arizona, I believe it was, that bought a bridge from London to put it on his development. And he thought he was getting the Tower Bridge, and he was getting sort of a little hilly bridge that really wasn't worth the powder to blow it to you know where. Desmond Heap was the one that sold it to him, so you had to watch what's happening. So Desmond's first major presentation here, planning lawyer, very good, well-known around the world. And he walked in, and it's gotten worse since then, and he had a stack this high that regulate this state. I am amazed. And that's the problem. We don't ever repeal anything, we just add to it. So starting with the regulations, and I apologize if this is something that may be, you know, too basic for a lot of folks here. Otherwise, if you have an interest in it, you wouldn't be here. Let's start with the state. The state, the purpose of the land use law was to preserve agriculture and to prevent urban sprawl. And so the land use law created a land use commission, an appointed body, and it also divided the state into 4 state districts: conservation, ag, urban, and then later rural at the impetus of this county. And it's then, I don't know if she was mayor, what she was at the time, Linda Lingle. And so this was added, and so the thing worth recalling and knowing about this classification is that 95% of the land area in the state is classified in either conservation or ag. Roughly evenly split, more in ag, less in conservation. And less than 5%, about 4.1%, is classified urban. Now, why is that important? Because development of any size or quality or density can't take place except on land the state classifies as urban. And indeed, the counties have no control. They have some shared control over ag land. I understand that, and rural land. But the right of the county to deal with the regulatory aspects of land only happens in that 4.1%, 4.2% of the land of the state is zoned urban. So we have this massive state overlay on regulation. Shortly after that, well, it depends on your definition of shortly, we sort of got it backwards, right? We passed the statute and then passed a general plan for the state. And we are probably the only state in the Union where the whole plan is in our statute. The statute doesn't refer to its plan. It's not too complex. It's got a lot of parts to it. But the plan requires all the decisions of the State Land Use Commission to be done in conformance with that state plan, and to give attention to a number of functional plans that came later that talk about some specific areas of planning, like education, higher education, transportation, schools, and so forth. And so it's another state mandatory requirement that the Land Use Commission and the Land Board, that board that runs that has the responsibility of running the Board of Land and Natural Resources, the Department of Land and Natural Resources, which has absolute power over the 40% of the land area of the state that is classified conservation. So you're looking at a system whereby, just from the state standpoint alone, in order for someone to, a private party, to use their land in a way that is developed in some fashion, more than ag, or indeed we have a separate carve-out for geothermal, it's necessary to go to the Land Use Commission, file a petition, and seek to have the land reclassified. We call that technically a boundary amendment, into the urban district. And that can take anywhere from a year to 2 or 3 years, depending upon the level of interest in that particular reclassification. So that before one gets to the county and the county regulatory scheme, which involves the building code, the zoning code, subdivision ordinances, development plans, which I think you call specific plans, if I recall correctly, on Maui, and general plans, you first have to get through that state system. So there you've got 2 or 3 years right there. And if that isn't time-consuming enough, the Land Use Commission, which again has as its main basis or reason for being, seeing to no sprawl and seeing to enough land for ag, which is sort of fallen by the wayside. It's now sort of the ag zone is really, for all practical purposes, a de facto open space holding zone. In order to get to that point, the Land Use Commission has now for about 25 years engaged in very detailed questioning about what exactly the landowner is going to do with the land. Now, there's some statutory basis for that, but not a lot. So instead of just focusing on its main broad brush strokes of so much for conservation, so much for ag, so much for urban, so much for rural, the Land Use Commission gets involved in a detailed fashion in exactly what the landowner is going to do with the property. Sometimes the landowner doesn't know yet, for sure. And I get calls all the time on other bases saying, but you know, I'm just trying to get the land reclassified urban, and here are several things we're going to do with it. We don't know precisely what we're going to do with it. It is, again, my opinion, it's none of the Land Use Commission's business. That's the county's business. Because, again, once one is through the Land Use Commission process and a contested case hearing, and therefore all the folks that get to testify, because it is a contested case hearing, then one goes to the county and you start all over again. With reclassification from whatever the county's classifying it. We call those, honestly, zoning amendments in one of the 14, 15 classifications that the county of Maui has. And then one needs, again, to go through a series of permitting processes, Coastal Zone Management Act, which is a state law but enforced by the counties, usually the subdivision level. If it's a largish development that requires a lot of lots, the subdivision ordinance comes into play. And so you've got another 2 or 3 years there, if you're lucky. And I'm sure most folks remember the litigation on before our state Supreme Court on 2 largish developments on Oahu. One of them was a development by Castle and Cook. And from the time that they conceptualized that particular development until they finally got to turn over dirt, which is, I think, the first time last year, 22.5 years. That's a lot of time. And someone is paying the interest rate on those loans, because I don't know any developers that pull out several $100 million of cash out of their own pockets and do the development that way. They borrow. So the interest costs are running. Guess where those interest costs go eventually? Into the cost of the product. Or occasionally the developer, not so occasionally, the developer goes bankrupt because it cannot sustain that level of delay in order to get, quote, entitled to do something that, except where the state and the county can make the point for health, safety, and welfare, they should have been doing in the first place. So that really, ever so roughly, is the regulatory framework that burdens land. And I haven't even begun to talk or said anything about the environmental impact statement law, which also is a requirement that also can add a lot of time to the, quote, entitlement of land. The second major thing, which happens unfortunately at both levels of government, state and local, are the so-called exactions or impact fees that are charged, again, in theory, for good and proper reasons. Development, a large-scale development, whether it's commercial or industrial or residential, is going to clearly require water, sewer, roads, often parks, schools, and increasingly a requirement for low and moderate, for low-income affordable housing, which is a sort of a separate area that I'd like to get to in a moment, because that's supposed to be helping the housing situation. Now, each of those exactions are granted on paying for that kind of infrastructure on the backs of the development community or the landowning community. In a perfect world, that's where your taxes would be going, because it's a government requirement. And so that hasn't happened in Hawaii for a very long time, and indeed, that's not so surprising. It doesn't happen much on the U.S. mainland either. So the Supreme Court of the United States, and here I'll get a little bit lawyerly, or try, heard two cases in the 80s and early 90s, Nolan versus California Coastal Commission and Dolan versus City of Tigard. And they established standards for how and when government could impose these exactions, these what we call conditions on land development, public conditions on land development. You don't get your permit, in some cases you don't get your zoning, unless you agree to these conditions. And the requirements are nexus. The development has got to be causing the need for the public facility, or solve a problem that the development is creating, like the need for water, sewer, roads, schools, parks. And the exaction or fee or dedication has to be proportional. So to illustrate both, if you're developing a shopping center, the government cannot impose a school requirement on you. You're building a school, it has nothing to do with the need for a school. If you are developing an industrial center, same thing. School exactions don't apply to you, or should not apply to you legally, because there is no connection, no rational nexus. By the same token, if you're doing a 1,000-unit residential development, you are driving the need for all of these things. And so you can be required to pay X amount or dedicate land for roads, utilities, schools, and parks. But it has to be proportional. So therefore, if you've got a subdivision of land into 20 lots, you can't require that developer, still causing a need for all these things, but a lesser need. So you can't require the developer to say, right, you're going to build a school. Because we need a new school, you're the tipping point, and your 20 units drive the need for a new school. Or you got to pay $3 million for an intersection and signalization when two roads connect near your property, because 20 units don't drive the need for that much. That's the issue of proportionality. And the Supreme Court said in a later case, doesn't make any difference whether the government is charging money or requiring dedications, the rules are the same. There has to be nexus, there has to be proportionality. So that leads, and you know, with respect to the government officials that may, how many government officials here, how many people am I alienating right now? And not many people holding up their hands. Okay, fine, whatever. I've never seen or heard of an instance where government is trying to line its pockets through these exactions or impact fees. I come from Illinois. I like to say it's the same, but I like to tell the story that when I was admitted to the bar and got my certificate, there were 7 signature lines and only 4 signatures because 3 of the justices were either on indictment or serving prison terms. You know, Illinois is a place where you vote early and often, and the home of the Daley family, which ran Chicago for a good bit of time. So I understand how that works. I don't get the impression that that level of venality and so forth exists in Hawaii or ever has. Again, the reasons are benign, but it doesn't stop the consequences of driving up the cost of housing. If you're going to charge a developer who's developing single-family detached houses an impact fee for roads, water, sewer, housing, affordable housing, schools, and so forth, you're likely to add between $70,000 and $100,000 to the cost of those units when they're done. And that is not going to, and that goes right on top of the price of whatever the market would do for the housing in the first place, as well as what all the regulatory regime has added because of all the time it took for you to get your permits to construct what you're constructing in the first place. So all of these things drive up the cost of doing land development in Hawaii. And it's especially acute at the housing level. We are, on every county, way behind in the need for middle income, let alone low income, let alone homeless income, let alone super affordable housing. We have a shortfall in the state of some 40,000 units. And we have never, in the history of the state, produced more than a couple of thousand units a year, even in the best times. So we're constantly falling behind. So it's a major problem. And the regulatory regime is responsible for a huge amount of that extra cost, either through the time it takes to get through the state and local government processing processes and to conform to the plans that need to be conformed with, or because the land development exactions and fees and because the land development exactions and fees add to it. Now, I'd be remiss if I didn't say a little something about housing exactions, which is sort of one of my pet issues for those of you that know me and the one or two folks who have had the debatably interesting experience of being in my class, like some of the people back there in that corner years ago in property. I teach the first year property course and everybody has to take it. So, you know, a research assistant that didn't have enough to do one time figured out that I have now taught property law to roughly 3/5 of the practicing lawyers in the state. So blame it on me. You know, whatever they got, either that or didn't take it to heart. So housing, and a huge issue with respect to affordable housing. Now, the problem that we have, and here I think probably I part company with some members of the development community, or I will by the time I'm done with this little brief analysis, there is no constitutional basis, no legal basis for putting a low-income, affordable workforce, whatever you want to call it, housing exaction on a residential development, because there is no connection between a developer building market housing and the need for low-income housing. There's a disconnect. There's a disconnect. My building 20,000 units for the market, if I could do it, does not cause the need for a single unit of low-income housing. And there is indeed a Ninth Circuit case from California, Sacramento, City of Sacramento versus some developers organization, which says that. And indeed, the case says quite clearly, if you want to do a low-income housing exaction, a workforce housing, first you do a study and a survey and find out how many units, roughly, this development is going to cause a need for, usually having to do with low-income folks working there. This was for a shopping center and hotel complex, if I remember correctly, and the way it worked was that the City of Sacramento funded a big 3, 4, 5 volume study and found that there were going to be X number of workers and that there was only homes available for Y number of workers, so X had to be provided by the developer in order to come in. Now here's of course where I part company with large members of the development community. Where the exaction is constitutional is on commercial and industrial development, because they're the ones that hire folks, some of which are going to be at the bottom of the wage scale. That's constitutionally defensible. I didn't say it was a good idea. I've had arguments with loads of people, developers and their attorneys, saying, look at Waikiki, there hasn't been a major hotel built in a long time. That's because it's so dodgy to build. You slap that exaction on it and they'll never get anything built. Now, I'm not an economist. I ignore the fact that I had a strong minor in economy when I was in undergraduate school about 11 years ago. And so I'm not saying that it makes sense in the bottom line. I'm simply talking about where it's legal and where it's not. It is not constitutional to put housing exactions on market rate housing developments. It is constitutional to apply them once a study is done to put it on commercial. To the best of my knowledge, we don't do it on commercial at all. We put it all on residential construction, which is insane because that simply adds to the cost of housing, and some segment of the market is going to have to be paying more because they are subsidizing another segment of the market, which is lower down. Now, I'm not saying that that's not morally appropriate. I'm not saying it isn't sociologically appropriate. I'm simply saying that as one of my colleagues in California said, there is no such thing as a free lunch. If you are going to add to the cost of development, it is going to drive up the cost of what is being developed. And that's just an economist rule, if you like, that is going to be there whether one likes it or not. Now, and I haven't even touched the regulatory regime over which we have no control. The Clean Water Act, the Clean Air Act, Section 404 dredge and fill permits. If one is going to do anything near a waterway that's going to cause fill and dredge to fall into a navigable waterway of the United States, in our case, including the ocean. The Endangered Species Act, which creates habitat protection for endangered species, which virtually mandates that the State Land Use Commission place such habitat in the most the conservation district, the Land Use Commission will place the conservation district, and then virtually mandates that the land board place that habitat in the most use-free protected sub-district. This is not my argument. It's been made for a lot of times. I have no solution for it, but it's a problem. So there are lots of things that add to the cost of development besides local and state regulations. We're concentrating on those that we have some control over, which leads me to a point that I will take a little bit out of order because I think it probably makes sense at this point. And that is that we all are going to have the opportunity to see whether or not we want to have a constitutional convention. And if we have a constitutional convention, then one of the things that cries out, a lot of things that cry out, I could be up for half an hour and give you my list of things that we could probably fix by the Constitution. But remember that the state constitution is one of limitation, not grant. Under our system of government, the state legislature can do anything it wants, and sometimes does, if not prohibited by the state constitution or given away to the feds as a part of the United States. It's a very important thing to remember. The legislature does not have to go and look to the state constitution for authority to do anything, as long as it's not prohibited. So what does that mean for the counties? Well, here's something that cuts both ways with respect to regulation and costs. We have the weakest home rule of any state in the union that claims to have a home rule clause. And we all found that out in the regulation, no matter which side you came down on, over GMOs, where a federal judge, two federal judges said, you don't have the power as a county to regulate in that area. You are preempted by state law and what the state could do. And that's in part because we have a very, very weak home rule provision. Our state constitution permits the counties to exercise home rule only for their internal organization, nothing more. And even that can be overruled by the state legislature if it passes a general law. We don't have home rule in this state. And I'm suggesting that it would be useful to kind of think about fixing that in some fashion without thinking what the counties might do more of and what the state might do less of. So I'm putting in a plug for a con-con. I think there's about a 20% chance of it happening for all kinds of reasons, but I really think that after 40 years, a con-con would be a good idea. And hang the expense. We've got more money in our various coffers in the state that we've had in 30 years. You know, so it's going to cost several $1 million. So, you know, that's government costs money sometimes, and some of it's well spent. I think that would be well spent. Now to the legal issues briefly. If you are a landowner and you feel overly aggrieved by a regulation that prevents you to do what you want to do with your land, this is going beyond the issue of all the time it takes and the overlay of various kinds of rules and regulations, then you have the right under the Constitution to file either a 5th or 14th Amendment challenge to that rule and regulation as a regulatory taking. That comes from a 1922 case, opinion written by Justice Holmes. If a regulation goes too far, it becomes a taking. Well, the courts have been trying to figure out what's too far for about the last 90 years. But there are, and there are basically, very briefly, two potential kinds. If a regulation takes all economically beneficial use of your property, I mean, if you can't even build a single-family house on it, then it's called a total taking, and under Lucas versus South Carolina Coastal Council, you get to treat that as if it were eminent domain. The second is more likely, where government takes just enough, leaves you just enough so that it isn't a total taking, and that's called a partial taking. Penn Central Transportation Company versus City of New York, historic preservation case, where the court said, you know, we really don't know how to deal with this complex issue, but here are two suggestions. We look at the economic effect on the landowner, and in particular, frustration of its distinct investment-backed expectations, and the character of the government action. And if you can make a case for a regulatory taking based on those factors, then you get a constitutional relief. Why haven't we had hundreds of cases filed over the years? Because the court, 5 years after that opinion, came down with a doctrine called rightness. And what that means in non-legal terms is, if you haven't exhausted your land use attempts to get regulatory change, you know, sought a variance, sought a special use, sought rezoning, whatever you could do after your first turn down, then you're not ripe. Prong 2, you have to seek compensation from the state. First, because Fifth Amendment doesn't say government can't take your property. It just says you can't take it without paying compensation. So you got to give the state an opportunity to pay you. The difficulty is that, so you go to federal court would say, not ripe, go to the state, then come back. You go to the state, you don't plead carefully, you deal with all the issues, you come back to the federal government says, oh, sorry, gotcha. This is the civil equivalent of double jeopardy. You can't relitigate because you had the opportunity to litigate it down there, and you did, and you got an answer, and you can't relitigate it here. So we ended up in a horrible situation around the country where nobody could bring takings challenges. What happened? Pacific Legal Foundation and a particularly bright young lawyer who just happened to be a former research assistant for the last 10 years has been winning cases at the lower federal court level all over the Southeast and the Eastern Seaboard, saying that state compensation prong ought not to be applied very much. The U.S. Supreme Court has taken that issue up on a petition for certiorari and will decide that case after hearing it in the fall. It will probably be the most major decision having to do with regulatory takings in the last 30 years. So that's where we are, and so hopefully we're going to get some relief in one fashion or another, and Dr. Akina is doing what I always do at that point. No hook, but hey, I'm coming up here, shut up. So as Mark Twain once said, it's a terrible death to be talked to death, so here's your first opportunity to get away. Thank you.
Let's have a big hand for Professor David Callies. Excellent. David, please take a little bit of water, relax for 30 seconds, and I want to invite members of the audience to come on up now and line up right here, because this information is being distributed and broadcast all over. We need you to come to the microphone and just form a line right over here. As you're walking up, and don't be afraid to do that, I want to ask Professor Callies to remark on something he said earlier. Did I hear you correctly that only 4 to 5% of all land mass in the islands is used for urban development, leaving about 95% unused? Is that right?
Unusable, that's correct. There are some things that are so-called ag subdivisions after the infamous, what was the Hokulea development?
That's right.
On the Big Island. Nobody does that anymore.
Well, just a thought experiment. What if we moved from 5% urbanization to 6%? Would we damage the aquifer? Would we hurt the environment greatly? But by doing so, I figure we would increase land supply available for development by 20%.
My land economist friends tell me that you can go up to 10% without a noticeable difficulty depending on which island you're reclassified. The only island that has anything remotely resembling a shortage, and even that has plenty of land to use, is Oahu. All the neighbor islands have way more land in ag than they need to have.
So in the midst of our housing shortage, are you suggesting that we actually have an artificial scarcity of land?
I think it's worked out that way. I think that's worked out that way, yes.
Well, that's very interesting. For those of us at the Grassroot Institute, that tells us it's not just the Jones Act that raises our prices.
No, no.
Anyone, any questions or any comments you have for Professor Callies? This is very rare that we haven't had people run up to the front, which tells me this is probably one of the most profound presentations we've had here at Grassroot on Maui, and I can see all of the brains engaged. I had the privilege of looking from the back and watching the audience glued to our speaker today, but here we go. If you'll just come on up and stand over here. Well, Chuck, why don't you open us up over here and just talk right into the microphone, ask Professor Callies whatever you will.
Oh yeah, my name is Chuck Thorne. I live in Hana. I found out years ago I live in the SMA district, and I'm over 2 miles from the water. So is there any way, I know they just decided to make the Hana Highway the boundary. Everything below the Hana Highway is shoreline, everything above the Hana Highway is not shoreline, and it was rather arbitrary. Is there any process that you can go through to get yourself out of the SMA if in fact you are a long ways from the water?
The short answer is probably not. I say probably because I don't know of any way of going about repetitioning. We had a case about 20 years ago called Topless. Really, it's a clean case. Topless versus, I think it was a Maui case, if I remember right. And, no, it was a Big Island case. And what Judge Heen, when he was on the Court of Appeals, said is, you get to object at the time that is being designated. And if you didn't do that, too bad. You waited too long.
We have a question from Norm here.
I've been in real estate for about 40 years as a broker and an appraiser, and it's getting increasingly harder to even appraise property because of the lack of comparable data. Was there any study done about the effect of the lack of affordable housing on our economy? And we know people are leaving the state, and we're losing the young, brightest people, and I just was wondering if, to make an impact on the politicians, that we may need a con or take some immediate action on some changes, and because of our our regulatory system, we got to show them that it's in our best interest to take action immediately, instead of waiting for a con or something else, because the problem is getting very, very drastic. As we say every day, and people with, this is a real sad case. I go to the Kaulua Library and I see a whole family homeless. What they do is they take a bunch of shopping carts and make a little compound out of it with a canvas over it. And it really saddens me to see that happening. Just want to.
Yeah, we should be doing better. I mean, there are ways of doing it. Lots of things are being tried. I think it's on everybody's radar now. It's a topic for another conference, but we're not going to tackle the homeless problem with exactions on the development community. It's got to be some measure of public involvement. I know it's usually a bad word in most circles for anybody that's, me and a few years younger, public housing, but you can't rely on the private sector to do a lot of that. The only person that I know, there are others I'm sure that's making a dent in the upper end affordable housing is Stanford Carr on Oahu. He seems to be pretty good at getting 200 to 300 unit projects off the ground, but it isn't real low housing, and Stanford's just real good with math and so forth, and he develops in state districts, which, if I might add just one quick thing, you all know about Kaka'ako. Got people here from Oahu, how much it's being developed and so forth. One of the reasons it's being developed so quickly, whether you think it's good, bad, or indifferent, is it's one-stop shopping, okay? The city and county has no land use authority over Kaka'ako. The Hawaii Community Development Authority does. You comply with their very well thought out plan, you get your permit. Bingo. You know, Stanford got a largish development for low-income, low to moderate-income housing up from the time it was conceptualized to the first people moving in 2 years. The city and county of Honolulu was looking at a similar contract area in a transportation, the buzzword is now TOD, transportation, transit-oriented development district. And they haven't gotten through the so-called entitlement stage yet in that 2 years. Take it from there.
Well, that was a good response and a good question. We have been tracking a brain drain from Hawaii, but what's happening is it's not just our young people who are leaving. Increasingly, middle-aged and elderly are leaving Hawaii because of the cost of living. We've got a question now from Hugh.
Thank you for President Callies. I admire your work. I reviewed the Hokule'a Law Review piece, and I really appreciated the comments that you made in that law review.
Very, very kind of you. You know, how do they say it? Flattery will get you everywhere? No, whatever.
So I just want to make a couple of comments. I'm primarily involved with the ag community here on Maui, and I kind of direct this more to us and you as well. One thing is that some of you may be aware, some of you may not be, that the planning department hired an outside consultant from the mainland called Orion Planning and Consultants, I believe, to do a comprehensive audit of Chapter 19, which is our Maui County comprehensive zoning ordinance. They actually came to Hawaii and to Maui last summer, and they, in my view, did a really comprehensive kind of exploration out into the community, both within the county and without. And they have published their findings and have presented those to the planning department, their initial findings and recommendations. Tomorrow, as a matter of fact, the planning department has something on, I think, the Land Use Committee, Council Land Use Committee's agenda to seek funding to actually implement this analysis, in other words, to actually amend Chapter 19. If you go to the planning department's website, this study is available. It's about 160 pages. It's a mind blower because they're very honest and frank about how over-regulated, how much confusion, how arbitrary it all is right now. And this is a consultant from the outside, and they say it in a very professional way. It's not critical. They're just saying, now's the time. So that's one comment, and I would certainly encourage everybody to support that. The other thing is, sorry?
What's the name of it?
Let's see, it's the audit of Chapter 19 of the Comprehensive Zoning Ordinance. But if you go to the planning department, I'm pretty sure you can find it on their website. I'm sorry, I don't know exactly. And just one other comment, and Professor Callies alluded to it. There's very little land in Maui County that's in the rural classification, the state rural classification. I mean, something like 3 or 4%. And it was intended that the rural designation or classification be that place where it isn't necessarily prime ag land, but it isn't appropriate for urban development either. So it's sort of an interface. But I articulate it as sort of like the appendix in our bodies. We, the people, aren't doing anything with it, and yet it's in our codes, it's in the county code, it's in the state statute, and it's a huge opportunity for us as a community to deal with the issues of the pressure that's on ag land, that so many people want to live in places that aren't necessarily urbanized, but we're very restricted by the state land use law and the county zoning around agriculture. So anyway, sorry for rambling on.
Thank you very much for the comment. Professor Callies, any response?
Yeah, just one quick thought. One of the things that would help in terms of the reclassification of property at the state level is if the state would undertake a comprehensive review of what land is in what category, and then at the Land Use Commission level make those changes. Now, it may surprise you to know that the statute requires such an overview every 5 years, and that the state has done it, to the best of my knowledge, 3 times in the last 50 years. So it's expensive, but it's a chance for all the stakeholders to throw in there, you got too much urban here, you got not enough over here, we could use more rural land classified in Maui, which was the source of the rural classification in the first place. I would be inclined to be pushing like crazy, let's do a comprehensive review and decide, aside from a particular development package that might be controversial, what land should be, quote, urbanized, what should stay in ag, where ag should be increased, and where the rural classification, which I completely agree is totally underutilized, should be put in. Write your legislator and say, you guys appoint the Land Use Commission, ask them, where's the 5-year review?
Before we go to our last couple of questions, I want to encourage you to take advantage of the opportunity to get a copy of today's video broadcast with David Callies. I'm going to listen to it again because there's a lot to learn, wouldn't you agree? You'll get that free of charge along with our newsletter and any other publication that we send out on a weekly basis. If you'll make sure that you sign up on one of these white cards, they're on your table, and if you don't have one, Sean in the pink shirt back there will be at the front table over here, and we invite you to give us any comment or any feedback as well. We look forward to that. And now another couple more questions. Here's Astrid.
Could I just
please
jump in for just a minute, since this is going to sound self-serving, I don't mean it to be. This book is $22. I don't get the royalties from it for a variety of reasons, so whether you buy it or not doesn't mean anything to me one way or another. It's not certainly the best book that could be written. In fact, a couple of chapters, if you're having trouble sleeping, I suggest you pick them up. I'll give you the chapter number, you'll be asleep in 30 seconds. But it's the only book. It's the only one. And it started out being funded by the state. And then the state wasn't interested in going forward to a second edition, so a coalition of developers put it together. And as you might predict, not a word about the book being biased when it was paid for by the government. But people were jumping all over me when it turns out that a development group got together and simply gave me the money and never touched the book after that. So, yeah, a little bit of prejudice. So
Thank you.
I just want to real quick, you can get the book by calling the UH Press at 808-956-8255, 808-956-8255. Visit the website online or go to your local bookstore. It's not that expensive.
It's worth having on your shelf, and looking at Regulating Paradise is the best roadmap there is to the convoluted roads of land use in Hawaii. And while Professor Callies doesn't receive any of the profits, he pays the growing excise tax on it in all sales. Astrid has a question for you.
Thank you so much, Professor Callies. I was absolutely amazed at the amount of information that you could bring us in very quick. I also thought that there is so much heart and aloha in this room, because I know that everybody in here was pulled for the same reason, which is, what can we do for our fellows on all these different tiers of difficulty with housing people? My question is actually just, first of all, I come from Wyoming. I'm on vacation. I'm leaving tomorrow. So I may be from the farthest away here today. I started a for-profit low-income housing company, and it's self-sustaining, grew 3 cities, 175 units. I incorporated here on Maui in 2003. So what I am asking as a question of everybody in this room is, how can we coordinate? Can we sign our emails up through this organization and stay in touch with each other as we have ideas, from regulating to land that's available to leadership, think tanking? So that's my suggestion. My question is, what would you say is the next incremental step in 6 months that you feel would move toward deregulating?
Move towards, I didn't get the last part.
I'm sorry, deregulating all this regulation.
It would help if the legislature were compelled to write a sunset clause in all of the stuff so that they have to look at it again. Once again, we add, and add. And we've got the tools to do almost everything. You know, if I had a nickel for every time someone said, you know, tax increment financing would be good if we had a statute. We've had a statute for 15 years. It's never been used. I mean, people don't know what we have already. So a re-examination would be useful. And there's something that the CON could do. Say every law having to do with the regulation of land sunsets in pick your 5 years, 10 years, whatever, unless the legislature holds hearings and reauthorizes it.
Thank you very much. And by the way, while we can't distribute our mailing list to other parties, if you'd like to be in touch with Astrid, she's at this table and you can stop by afterward. Our last question today. Ma'am, your name? Carla, here we go.
Hi, my name's Carla. I'm a resident of Kihei. And it seems like one of the solutions that's maybe at the county's hands is for dealing with the lack of urban 5% land use is density. And this county, as well as others, are looking at ohanas without any restriction on lot size to allow people to build ohanas, and I guess I have some concerns against that as a remedy to provide more housing for people by filling up the limited amount of urban zoned property that we have.
Well, we are talking again at the bottom level, which is a whole different aspect of affordable housing generally for the lower middle class, the middle class, the upper middle class, pick it, the higher end, economically deprived. It will help at the bottom tier, arguably, okay, because you're not going to have folks that have other choices going to be living on a small house on someone else's lot. So is it possible to work? Yes. I would tighten up the regulations on that just as I would on rental housing for the lowest level, or indeed the sales of folks at the lowest level. What we have done, which is beyond belief in my view, is to permit a developer to construct low-income housing at which becomes at the rental and the for sale level, no longer low income after 10 years. Okay, you know, the suggestion by, I think, one of the offices in the state said 30 years. I'm good for 50 or 100. I mean, I don't see any reason why we have to start over again every 10 years and see part of the housing supply for the worst off to go into the general market. It makes no sense to me. Yes, that particular family gets a windfall and they're suddenly middle class. And the folks that need that housing don't get it because it's not part of the scheme anymore. It's crazy. I've had arguments with housing directors in 3 of the 4 counties. It needs to be a long time. I understand from the developer standpoint, it could affect their financing. I'm sorry, but life is hard and sometimes short, and those resources need to be kept. If we're going to do low-income housing at all, it's got to stay low-income housing. It can't go into the market afterwards. It makes, again, my opinion again, it makes no sense.
Thank you. Professor Callies, Chuck over there will have a question as soon as you're done. He's at this front table, and we'll answer it then. I want to ask one final question, just your comment as we close. From time to time, we become aware that there is some corruption in the system, that there is a friends and family game, a cronyism, or a pay-to-play, or it's who you know. And that may be the tip of the iceberg, but what you suggested today is that underneath the surface, there are just a lot of good intentions that went wrong, that the system itself isn't necessarily the way it is because of corruption, but because of poor thinking and good intentions, and that there's enough of that to have made the whole land use system, as well as the amount of housing that's available, a problem for us. Is that right?
That's my sense, at least compared to Chicago and Illinois, okay? I might as well really blacken my city of birth and where I came from. Having said that, as a totally random off the subject, the other thing that I would add to a con is to make the legislature apply the same ethics law they apply to everyone else. They have exempted themselves by statute. I think that is outrageous. I'm surprised that anybody born here That leaves me out. Anybody born here would put up with that. There is, the city councils have to do it, the city commissions, all the county officers, but the state legislature is exempt. I don't know what's under the carpet. I don't think much, but I don't think that's the point. They ought to be responsible for the same ethics laws as everyone else is.
Food for thought. Everyone give a big hand to Professor David Callies. Order regarding regulating paradise. And if you'd like a copy of today's presentation or just to stay in touch with us, make sure you give your name on one of these white cards. Thank you and aloha. Thank you for being at the Grassroot Institute. Aloha.